Hey everybody, Mark Westcott here with Juanita Maiden again, and guess who's in Cairns and guess who's on the Gold Coast.
Well, we can see your background, so I think it's easy to work out.
I'm rugged up in a jumper and so on, and you're in your
I'm
tropical best up there,
coming from
Juanita. So
tropical Cairns today. Yes.
broadcasting from Cairns. So anyway, great to have you here. Thanks for finding a spot in Cairns to join the broadcast today, Juanita. So we've had some great feedback from last week's session when we went through all those issues from last week, and I'm just going to throw this up here on the board too. With one of Juanita's colleagues, we've been doing some webinars in regard to how to stop the family squabbles, and if you just want to register for that webinar, just go to ruralbusinessdepot.com, and that will take you straight to a registration page for the webinars if you want to come on and have a look at those. We've had a number of people comment great feedback in regard to the content and so on, so it's nice to be able to create some value as we are doing here again today.
Absolutely.
So thanks. So today we're going to touch on the issues. 2 weeks ago we touched on all the issues, all the documents needed in a good estate plan. So today we're going to touch on this as estate and succession mastery. So you're the guru here today, Juanita, you're the clever one. So we're going to touch on all the things you need for a successful succession plan, certainly in regard to documentation. I mean, apart from all the obvious issues that we talk about in the webinar and so on, but in regard to family communication, intergenerational communication, stopping conflict, and all those sorts of things, knowing how to start the conversations and so on. Once you get through all those and you realise you need to do something about your succession plan, today let's talk about what that entails. So do you want to just roughly go through an overview? Thanks.
Yeah, absolutely. And probably to clarify those that aren't quite clear, because it's not obvious to everyone what the difference is between our estate planning and our succession planning. But in very simple terms, our estate planning is planning for how your affairs will be handled after you pass away. And we've covered a lot of those topics already. Succession planning is more focused on in your lifetime as well as afterwards. But we're talking about how the succession of entities, be it partnerships or companies or trusts, etc., will pass on it could be from generation to generation, and that can be during one's lifetime as well as after one's death. So succession of entities, I suppose, succession of and control of entities. So we've got a few key agreements that we're going to cover today, which address different types of entities. Okay,
because when you think about the work that I do more so in regard to rural families and so on, I mean, we strike all sorts of arrangements. People own stuff in partnership. Husbands and wife own the property and all the stock and so on, simply in a partnership, and that's one way. Sometimes they might have a company that owns the stock, but they still own the property in their own names, and other times there's trusts involved, or which is more rare, but so let's cover all of those.
Yeah, although we do see a lot of those, Mark, because the trusts certainly went through a phase where they were the flavour of the month or the year or the decade. So we are seeing a lot of that, and probably just to wrap that little bit up that you just said, Mark, we often also see a combination of all of those. So we might see a trust with a corporate trustee, or we might have a company with a trust as a shareholder, etc., or partnerships of trusts. So they can all become a bit of a puzzle, a good puzzle for us. We love puzzles.
That's right. Absolutely, we get to use our brains. Absolutely. But and I guess one example recently, we had the properties were all owned in joint tenancy, I think, and yet these clients had a holiday home which was owned in a family trust, and they had something else which was owned by a company. So yes, it's an absolute mix of entities. But when you look at succession planning, Juanita, what are the partnership agreements? I guess are people in partnership is a common one. So what are the sorts of things you need to look out and And if you're in partnership and you die, what are the rules in regard to what happens to the partnership, the assets, and how do you create succession?
Well, a lot of people are really surprised by this fact about partnership agreements or partnerships, is that on death, unless you have provided for what will happen in a partnership agreement or in your will, the partnership will dissolve. It's dissolved on death. So that can have various ramifications which may be quite unwanted, financial as well as control and passing on. And I'm sure most accountants would much prefer that that doesn't happen unintended, that the partnership becomes dissolved. So really important, if you're in a partnership, the very first thing is to make sure you either address the succession of that partnership by a separate partnership agreement or in your will.
I think I remember in grade 10 bookkeeping, we learned about structure.
I was going to be a bit cheeky. That's not that far back, is it, Mark?
It wasn't that far back, it was only a couple of years ago, but grade 10 bookkeeping, we learned about partnerships, and as soon as one died, I remember back then the partnership was dissolved. So, so how do you, you're going to tell us, but I mean, how do you guard against that?
Well, it's pretty, the way to guard against it is pretty simple, by providing, in your will, first of all, a clause that might address how you would like your share in the partnership to pass on, and also particularly how you want the financials treated. So, and of course, we're talking about partnership agreements here today, as opposed to wills, and this can all be documented in your partnership agreement also. Often we'll see on someone's death there will be unpaid present entitlements for trust or loans or unpaid dividends and all this sort of thing in balance sheets. And so they're assets of someone, often assets or liabilities. So in some cases that can be passed on death. So we would recommend that for all of those people that are entering in a partnership, and we'll go on to talk about companies and trusts, not so much trusts, but particularly companies and partnerships, that you put in place this agreement so everyone is clear what happens on someone's death or when someone wants out, as we'll talk about a bit later. So what will we go into sort of things we're looking to put in there now, Mark, or?
Yeah, well, yes, absolutely. And look, one of the questions I was going to ask you, Anita, is, and so let's be honest about this, what percentage of people who have a partnership and their accountant is, doing the books on it every year, how many people who actually have a partnership actually have a proper legal agreement around that partnership, proper partnership agreement?
Not enough, and not enough, and just dropped my phone. And the problem being, well, not the problem, but the reality being that when people are entering into a business or a project with someone else, be it in a company or a partnership, things are usually great and it's exciting, and everyone's
they like each other.
They like each other, and nothing's bad's gone wrong. And so, and also too, there's a limited budget. Like lots of startups will have a smaller budget, and there's priorities to spend your money on. So a lot of people might see this as not top of the priority list. So for that reason, all those reasons, often these agreements won't be put in place by people. And unfortunately, that is when the best time to put them in place is when everyone's happy and getting on and can speak clearly and about what they, would like to happen if things don't go well, because it becomes a proverbial fight if things don't go badly and it's not documented. It might be a falling out when I say badly, but it also might be someone's, unfortunate, unexpected death. So, very often they're not in place.
Okay, what are the key requirements of a good partnership agreement before we go on to companies?
Yep. Similar things in both, with some extras probably in a shareholders agreement. But some of the things we're looking at is what the contributions are by the respective partners to the setting up of the business or the project. Whose roles are what. Some partners or some shareholders, as we'll talk about, like to be active and are involved in the business, but some are silent. So what is the expectations around whose roles are what and what people will do? Probably a really, really important one is if there is a dispute or a disagreement, how will that be resolved? So what is the process for that to be resolved? So everyone is clear on what that will look like and how they will get to some sort of resolution. You can put in things like restraint of trade. So if the partnership or the company, the shareholders part ways, will there be a restraint of trade on one? Is that important or is it not? As we just
Not when they're
spoke
friends. Not when they're friends. They'd never expect that would happen, so they wouldn't worry about that.
No. That's right. Then the fights start. But as we've already spoken about briefly, in that partnership agreement, for example, should be what happens when one partner wants out. And it might just be on good terms. It might just be that they're moving town or they've got a family now and they have to focus on something else. So it may very well be for good reasons, not always bad reasons. We shouldn't always suspect the worst. So in those sort of cases, how will the partnership share or the company share, how will that be valued and who by? And what is the process for selling that share in that partnership or in the company? Does it have to be first offered to an existing partner, or can it be sold to a third party? So these are all questions we would ask people when they're setting up their entity, because often they haven't thought about it. But by putting these processes in place at the start, everyone's really clear what will happen if any of those sort of things arise down the track.
Yeah, and I guess a good example of this, Juanita, would be accounting firms, legal firms. I mean, and it may be a partnership of companies or whatever, but in the day, where certainly a lot of the big groups, accountants, solicitors, and so on, there was partnership arrangements, and you had these young junior guys coming in, and you had the guys in their 60s. And you really need to have some specific rules, don't you, about what's going to happen to certain people, in certain situations like retirement or whatever.
Because if you think about it, if there isn't provision made for what will happen, so let's use myself for an example. So if I was a partner in a law firm and I decided if something happened to me one day, or I decided I wanted to sell my share to someone else, my partnership interest, maybe those existing partners wouldn't want to deal with who I want to sell it to. Or if I left everything in my estate to my husband, all of a sudden, my business partners are dealing with my husband, and he's great, but they might not want to do that. So
it's his lawyer that they'll have the trouble.
That's right. So these are consequences that can happen if you don't plan ahead and document that. Now I'm just gonna duck down and pick up my notes that I dropped here, Mark.
No, go for your life. So I'll just ad lib while you're doing that, and while
we're back.
Your earplugs back in. No, that's fine. So let's talk about companies. So we've talked a lot about. I mean, there's a lot of similarities between companies and partnerships in regard to needing to have rules or partnership shareholders agreements. I guess a different name. You're a shareholder if you're in a company.
Yeah. So as we said, with the partnership agreement, I guess just to wind that up, the main thing is putting something in place so the partnership doesn't dissolve on someone's death. Shareholders agreements is a little bit different. So when we're establishing a company, there will there will be shares in that company held by individuals or by trusts, for example. Now, you don't leave a company in your will, and you don't leave the assets that are owned by the company in your will, but you leave the shares in the company in the will. So that's what we're really focused on here, what we want to happen to those shares when someone passes away. But as I alluded to before, a shareholders agreement isn't all about where those shares may go on death or on exit. It also covers all those things that I spoke about. So what will be the roles of the directors? will the shareholders be able to nominate their own director? What will be the roles and responsibilities of the shareholders and or the directors? Again, how do we resolve disputes? Particularly important when you've got two shareholders, and you've got a 50-50 vote. So what happens when you just disagree and you've got a deadlock? So processes to resolve that. Again, restraint of trade. But I think probably one of the key differences with this agreement to the partnership agreement is that role of directors that you have. So, being very clear.
You can own shares but have no say, effectively.
You can have no say in the, I suppose, to have no say in the day-to-day administration of the company, because that would be the directors. However, the shareholders could potentially get rid of the directors. But what does the shareholders agreement say? Is that, do they have a right? Does someone have a right to put their own director in? So some companies might have a board of directors. We spoke before about, when a shareholder exits. So again, how will the company be valued and by who? If I want to get out of the company, and if we're in a company together, Mark, and I want to get out, do I have to offer you my shares first, or can I just sell them to the next door neighbour? So, no. So,
nothing against my neighbour.
Another important one that just popped to mind too is if the partnership or the company, if things don't go well, and the partners or the shareholders are required to put more money in, what are their obligations there? So, not everything is going to be perfect, as we know. So being very clear in that situation, what are the respective obligations as far as putting money in at the start and if things aren't going well? And to the flip of that, what are the dividends that the shareholders are entitled to and when? So do we want to retain money for a few years in the company, or every year are we going to pass out dividends? So again, the sort of conversations that aren't first and foremost in your mind when you're bright-eyed, bushy-tailed and setting up this sort of structure.
It's like a marriage in a lot of ways, isn't it? Everyone goes in with great intentions. It doesn't always, unfortunately.
It's a bit like a prenup, isn't it? A prenup for a company or a prenup for a partnership.
And look, for those people who say, why do these guys try and dredge up all the bad things that can happen? I mean, well, the truth is, if nothing goes wrong and everyone's happy, then that's fine. You don't have arguments around these sorts of things, but you only need one little thing to go wrong and there to be a dispute about something. And I mean, that's what you get paid for. That's what we get paid for, is to think about all the things that can go wrong. Look at the worst case scenario, and make sure, by asking the right questions, make sure that we've covered off on all those issues, so that people still can survive and get on. And there's rules around behaviour and how to get in and out and so on. So
yeah. And I suppose, speaking of generational succession, it's important to have that conversation, whether if you're in partnership or if you're in a company arrangement with someone else, do they want to go into business with your children and your next generation? Like, what does that look like? Because that might not necessarily be the case.
Yeah, look, absolutely. That probably is a good segue into buy-sell agreements and share purchase agreements, whatever you want to call them, in regard to companies especially, how many companies have you seen where there is no buy-sell agreement? I mean, there might be rules around shareholder. There's a lot of people have maybe a shareholders agreement which tells them how many weeks holiday they can have and what are the rules for if they have a blue and when they've got to put money in and all those sorts of things. But a buy-sell agreement really talks about what you just said. If you want to sell your shares to your next door neighbour, and I don't get on with your next door neighbour, how do I have some comfort in knowing that you've got to sell them to me first, provided I'll pay you the money.
Yep.
So buy-sell agreements, let's touch on them.
Yeah, and additionally to what you've just said, it may not only be on someone's death, it may be on someone's incapacity. So if I was to get unfortunately hit by a bus tonight and could no longer work in our company, if we had one together, Mark, what does that mean then? So who steps in or doesn't step in then? but a buy-sell agreement will often incorporate an insurance policy. So if I was to pass away, you might want to buy, or if I was to be incapacitated, buy my share. But how do you afford that? So often there'll be an insurance policy taken out on the key man or the shareholder. So if something happens to them, the continuing partner or the continuing shareholder has access to finances to be able to purchase the other interest. So often intertwined in that buy-sell agreement, and it just particularly sets out those scenarios, what happens and how when someone can no longer be involved in the entity.
Absolutely. Look, back in my previous life, which was in the insurance business, most of my work was involved in doing partnership insurance and so on to fund these sorts of buy-sell insurance and these buy-sell agreements. And I remember the easiest way to get people to think about whether they needed insurance or not was to say, well, how would you like to be in business with your partner's wife's next husband?
Absolutely. Usually the answer is no.
Oh, I don't want to be in, with the partner's wife's next husband, lawyer, or either some other well-meaning friend who's going to come in and give your partner, your ex-partner's wife advice on what she should be doing and so on. And the simplest way was just to, fund the purchase of the shares with life insurance in many cases, and it was very clean and very easy too, so that. If you've got 5 people in a partnership, one person dies, the spouse ends up with the right amount of money and the shares go to the other 4 partners, for example, and everyone can get on with their lives and no one's disadvantaged. Everyone has certainty, that the partners have certainty that they haven't got to deal with some random outside person, and the spouse of the deceased partner, they've got their money and they can get on with their lives. So, it's just a clean way of doing everything. So very important.
And the last thing you want to be worrying about, on top of all the other concerns and emotional challenges during that time, is having a fight about the shares in the company or the partner, the share in the partnership itself. So by having this document, it can take so much, so much.
Well, you're going through emotional grief at the time anyway, emotional paralysis and all those things. And if there's certainty is just a lovely word. I use it all the time in what I do with estate and succession planning, is that you want to create certainty, confidence and security for those that are left behind. Moving on from there. So now let's talk about trusts, and where you've got a family trust or whatever sort of trust. What do you do in creating it's really, because the trust is not owned by any individual, is it? It's a legal entity of its own, and you have appointors and trustees and so on, and that's probably a conversation for another day, those different roles. But how do you make sure the succession of the ownership, or not the ownership, succession of the control of the trust from one generation to the next? So, for example, if mum and dad set up a family trust years ago and they own all this real estate or a business or whatever, on their death, either one death or both, how do they make sure that passes down to the right people in the next generation in regard to the control of that trust?
Well, the control is the key word, isn't it? So again, you can't leave the trust in your will, or the assets that are owned by the trust in your will, or well, I was going to say in your lifetime, but we'll probably not complicate things. But the key here is passing on the control, and the way we do that is consider what the roles in the trust are. And you just mentioned the appointor or principal of the trust. And this is the most important role in that respect, because the principal or the appointer of the trust has the overarching power to remove and replace the trustee. And the trustee is the person who administers the trust day to day as such. So the key thing here is thinking about, on your death or on your incapacity, who would you want the control of the trust to go to? And the answer, whatever that answer is, that is best documented in a deed of succession of trust, and it can also be documented in your will. But that being absolutely crucial, because if you don't document that, then the default will be whatever the trust deed says, and a lot of people don't know that, or it could be just who you don't want it to be.
Yes. I mean, there's a whole range of issues here, such as divorce and so on. What if you've been divorced? And you know, once again, that's about, we talked about delinquent documents and making sure all your documents are up to date. But I mean, you know, you need to protect too that if one husband or wife dies and it defaults to the other person and they remarry, you know, what danger is that to you know, the succession through to the next generation?
Or it may default to your legal personal representative, and that goes back to the executor in your will. Another important thing to think about with trusts is leaving if you have a company as a trustee, who are those shares left to? So what will happen to the trustee company on your death? And so that's something that also should be addressed. And finally, on that topic, a very important thing that a lot of people forget is what's in the balance sheet. So if you are owed or owe the trust money on your death, then when you die, it's now owed or owned by the estate. And that can cause some real issues, particularly if there's not a lot of cash in the trust. So it's just really important in these documents to document who will control the trust, who will take over the shares if there's a corporate trustee, and who will be entitled to any balance sheet liabilities or unpaid present entitlements.
Yeah, look, I just see it's worth, thank you. And Juanita, and it's just worth touching on too. You know, it's all very well to leave the shares in the trustee company of a trust to and think that that's done the right thing in passing on the control. So let me reword this. The trustee may well be a company and the shares in that company, and so in your will you pass on the shares to who you think is right in the next generation and think, well, wow, that gives them control of this trust. But I mean, the real issue is the appointor of the trust, and without making this too complicated, you can give the shares in the trustee company to whoever you like, but I mean, if the appointor becomes someone who's not a friendly, they sack the trustee company, and your family may end up with no control over the trust at all. And the reason I bring this complication up is that what we're trying to show here is that life isn't necessarily just simple, and this is a perfect example of whether you've got a partnership, whether you've got a company structure, whether you've got family trusts or some form of trust, or you've got any combination of all three of those things. You really need to have a due diligence every now and again, and just make sure that your, what I call delinquent documents, make sure your documents aren't delinquent, and make sure your intentions at the time, because people's intentions change every few years. You know, kids grow up, they get married, they become delinquent for periods of time during their university years or whatever. And you know, you wouldn't want to give control to them at certain periods in their life, or you'd want two people, or you know, you get divorced, married again, all these sorts of things. You know, it's so imperative to not just put this stuff, as we were saying last week, in the top drawer and just, you know, think, oh yeah, I've done something about that years ago, it's all going to be fine. You really need to have a full medical check on your legal documents. You know, every 3-4 years, I would suggest, and you know, go see someone who knows what they are talking about, and to get all this stuff checked, audited.
That's right. And so if you have a company or a partnership or a trust and you can't answer any of those questions that we've asked today, then you need to have that addressed. Yeah,
just give us a call, or give Juanita or myself a call, and we'll point you in the right direction and how to get an audit done. So, you know, 2 weeks ago we talked about all the documents you would need from an estate planning point of view. You can go back and have a look at those either on YouTube or in the Facebook Estate and Succession Mastery group. Today we've talked about the documents you need as part of a succession plan, depending on whether you've got a partner, it doesn't matter, partnership, company, trust structures, or whatever. So I hope you're finding these useful. And Juanita, thanks for your time. Thanks for taking time off from your sunbaking up there in Cairns to come and do this today. So I appreciate your input, and to everyone watching, thanks for watching, and we'll see you next week.
Thanks, Mark. Thanks, everyone.
See you later.